and welcome to Stowe Talks, a podcast designed to help those going through a relationship breakdown and all the troubles this brings. I'm Matthew Taylor.
And I'm Liza Gatchell, family lawyers at Stowe Family Law. And today we are looking at prenups, postnups and petnups.
Hey. That's very, very snappy. I like the alliteration.
So I guess the best place to start would be with what is a prenuptial agreement?
Prenuptial agreement. So let's deal with prenups and postnups together because they are effectively the same apart from some very obvious timing issues. So nuptial agreements are a form of agreement that you can enter into that sets out what happens with your assets in the event of divorce, effectively. So a prenup is one that you enter, and that's the one sort of everyone knows about, and they've got this kind of slightly celeb-y, super wealthy mystique about them, but that's not actually true. And, it's before you get married, what will we do with our assets if we separate? And the postnup's exactly the same. It's just one entered into after the wedding. So what's the point in them, Lisa? Why should someone think about getting a nuptial agreement?
Okay, so these are bespoke agreements, so they're tailored specifically for your relationship, and there are a number of advantages and disadvantages to nuptial agreements. So if we go through the advantages first, I suppose they provide you with clarity. So you're both able to define what certain assets are. You're both able to say what's going to be classed as non-matrimonial property, what's going to be classed as matrimonial property. They provide you with a degree of certainty in that you are setting out how your finances will be divided in the event that you later divorce. Although I will caveat that with the fact that these agreements are not 100% binding on judges in divorce proceedings, but we'll go into sort of the legalities around it a little bit later. They provide you with transparency. So there will be full disclosure. So you'll have an idea of what both parties' assets are so that you're able to properly negotiate and enter into these agreements, knowing what it is that you're accepting or giving up as far as claims are concerned. There's the possibility that they can save you money. So whilst you will incur legal fees in having a prenuptial or postnuptial agreement drafted, those fees will pale in comparison to the fees that you would incur in divorce proceedings further down the line if you have hotly contested proceedings. It allows you to protect your assets. So it allows you to attempt to ring fence certain assets, and that may be assets that you have brought into the marriage, or it may be an inheritance that you have received. It may be assets that you want to save for children that you had from a previous marriage or relationship. They also give you the opportunity to provide a certain degree of debt protection. So you can be protected from debts incurred in the other party's name that they may well gather, if you like, during the course of the marriage. It allows you to protect family members. So if you've got a family business or inheritance, or there's family trusts, etc. involved, then obviously you can provide provisions for those. Hopefully, if you have a well-drafted prenuptial or postnuptial agreement, it's going to improve your communication and it's going to minimise any acrimony between you on divorce, because you're going to have all of these conversations up front from a place of love rather than further down the line once there are tensions within the relationship and the relationship has broken down. And I mean, as far as advantages are concerned, I suppose it allows you to review it. So again, this is probably something we'll talk about in a minute, but you can review and reach an agreement based on your own terms, if you like. So it gives you a sense of independence and autonomy. Oh, there's a word, autonomy, as to what you're going to agree. If we run through very quickly then the disadvantages of these types of agreements, I think the main one is that people will find them unromantic. Yeah. We shouldn't be discussing these things when we're approaching a wedding or even after we've married. It's very distasteful to be discussing finances and a potential divorce at that time in these terms. Often with these types of agreements, there is an economically vulnerable party. So one party tends to have more assets than the other, which is where these agreements tend to come into force. So, there is a risk there. We need to make sure that the financially weaker party isn't entering into these types of agreements when they shouldn't be, and that everything has been taken into account. As I said, they're not legally binding, so we will go through that. But, we don't live in a country that has statutory provisions in relation to prenuptial or postnuptial agreements. So they are They are definitely worth having, but they are not 100% legally binding. As I say, we will go into that in a little bit more detail. And I guess the main two disadvantages are legal fees. As I just said, it's advantage and a disadvantage. You are going to incur legal fees in relation to this. And if you have a long and happy marriage, then potentially, arguably, those fees have been wasted. And also changes in circumstances. Circumstances will change, which can then impact on the agreement. So, sorry, I was a bit long-winded there, wasn't I? I went through.
No, I just have nothing to add. That is the full list of pros and cons. I'll get my coat.
Okay, I'm going to give you the law then, Matt. So,
right,
what's the law? What's the law on these agreements?
Fine, you get all the nice stuff about how they can benefit people, and I can be the boring one talking about law. We can do that.
Why, thank you.
So, okay, not legally binding insofar as it is not a case that whatever you wrote in a nuptial agreement is the final answer at the end. Carry on your way. But heavily, heavily persuasive and a real strong factor that the court should take into account in most cases, provided that certain criteria have been complied with. And these criteria are largely set out in a case from 2010 from the House of Lords before it became the Supreme Court, called Radmacher and Granatino, which is a story about a German heiress who had a prenup and whether it should be upheld in England and Wales on divorce. And effectively what that case said was the court decided that yes, the prenup in that case should be upheld. And it set out some guidelines for the sort of criteria that would lead a court to uphold a prenup. And the main pointers are that both parties have to have independent legal advice. It has to be that there has been full and frank disclosure about assets. And it has to have been entered into sufficient time prior to the wedding for a prenup, obviously not a postnup. But the key point about that is so that there's no suggestion of duress. So I'll just break those down a little bit. So independent legal advice is pretty straightforward. If you sign up to one yourself, a DIY prenup, the court's going to say, well, you can't. The whole essence about a prenup is that you are contracting out of certain the court having the ability to do certain things. You are giving up claims. There is normally a weaker party. So the legal advice is, look, if you sign this prenup, you probably get less on divorce than you would do otherwise. But you might want to do it anyway because it's important to start off the marriage in the correct way and you believe this is fair and reasonable. That's commonly my advice to a financially weaker party. So you are inherently giving up some claims. You have to know what you're giving up to be able to give them up sensibly. So the court says that both parties have to have independent legal advice. There also has to be disclosure. Not only do you have to know the claims that you're giving up, you have to know the assets that comprise the claims that you might be giving up. So if you don't know that your husband-to-be has got X million pounds in the bank account, well, how can you then agree to not pursue those claims? So there has to be full and frank disclosure. They're pretty keen. They're the real kind of two core points as far as I see it. There's a timing point. And in Radmacher case, it was sort of said that prenup should be entered into, I think, 28 days before a wedding. There was a Law Commission report on prenups in around, I want to say 2012, but someone cleverer than me listening to this will probably pull me up on that, which said ideally 3 months before a wedding. And that 28-day thing has taken on sort of quasi-mythical status with family lawyers. A lot of the recent case law doesn't support that. And actually, and I've done a number of prenups where they have been negotiated for a long period of time first, where the parties have agreed terms, maybe a year in advance, when they got engaged, and it was pulled together and actually signed 14 days before the wedding. The court in those cases isn't going to say, well, it's within 28 days, so tough, we're going to tear it up. What they're going to look at is the idea behind that is no one is standing at the end of the aisle and goes, here you go, sign this or the wedding's off. It's about duress and about making sure people have got time to consider things. So there's a timing point on prenups. Now, that obviously doesn't apply to postnups. But that's basically the structure. And that sits underneath the overarching discretion of the family court. So as we talked about lots of times on these podcasts, is what the family court has to have regard to a variety of factors in Section 25 of the Matrimonial Causes Act. And the key thing is needs. So it's the needs of the parties, and the primary thing is the needs of a minor child. And what you cannot use a prenup or a postnup to do is contract out of needs. So for court, and most of the decisions, the published decisions in case law, where a prenup has been challenged, it's because someone has said, well, actually, now we've come to divorce, this agreement doesn't meet my needs. And it may be that the court then looks at it afresh and says, well, no, it doesn't meet your needs and you should need a bit more, but it's not going to tear it up and start doing a 50-50 on the whole of agreement. So what agreement can't contract out of needs, can't contract out of a child's needs, but what it can do really successfully for someone looking to protect assets is to put a ceiling on those needs, so it effectively minimizes potential claims. So, I describe prenups to clients as being like insurance products. It's a sort of insurance against divorce, and in the same way that hopefully you never cash in a life insurance, a critical illness policy. You pay the money and you hopefully waste the money. It's sort of the same thing with the prenup. You pay the money, you've got it there if you need it, you review it over time, but hopefully you don't ever use it. But if you do come to use it, then either it saves you a load of money because you've just got an agreement, or it's going to put a ceiling on needs. So your exposure to claims, if you're the financially stronger party, isn't as great as it otherwise would be. So, I mean, how do you, when you're having those discussions, because you mentioned this, Lisa, the conversation, so darling, I'm very happy to get married, shall we get a prenup conversation? Like, probably not the easiest one to have in life. How do you approach that with clients? I use the insurance policy analogy. I talk about how even the weaker party can have a bit of financial security from it. I think that's really important, the certainty point. How do you speak to clients about it and talk to them about the benefits and decide whether a nuptial agreement is right or wrong for them?
Yeah, I have to say, most of the clients that probably come to me have already decided, or at least one party's already decided, that a prenuptial agreement or postnuptial agreement is right for them. I definitely have used the insurance analogy before, so comparing it to insurance policies, because I think it is very similar. And, marriage is a commitment, isn't it? Marriage is a commitment. We've talked about it before. It's a contract, effectively. And what these agreements are allowing you to do is discuss the terms of that contract, as awful as that sounds when we're talking about romantic relationships. But I think, going into a marriage, being able to communicate about the difficult things like this really does set you up in great stead for the conversations that are bound to come up during all sorts of circumstances during your marriage. And I think, you would hope that relationships are full of trust and openness and good communication. And I think this is just one part of that. It's a difficult conversation. Don't get me wrong. There's no easy way to have it. But I think it's so important to be really upfront, because whenever we have issues, whenever clients come to us about anything, quite often one of the core problems is simply that they've both reached different assumptions on the same issue. So whether we're talking about divorce or cohabitee disputes or child arrangements, often it's like, well, I thought it would happen this way, and the other party says, well, I thought it would happen this way, and that's where we get our disputes. And this really does allow them both to kind of just go into it very openly and have those conversations early on, rather than kind of letting those assumptions really bed in.
Yeah. And one of the strengths and weaknesses of family law is that those assumptions, if two parties have got opposing views on something, they're not necessarily both wrong. It's a discretionary system, so there are lots of answers. There are often some very wrong answers, but there's never, ever one absolutely 100% right answer, really. So these different circumstances, they can both be right. I think that's one of the strengths of family law, because it's discretionary and the situation can be adapted to meet the needs of individual parties to ensure fairness. But the corollary of that is that when you're seeking for fairness by being able to be bespoke, is that you lose that certainty. And there are a lot of people who would disagree with me about that and would say that actually we need more certainty and less discretion, because why should someone go into a marriage not knowing what would happen at the end of it? I think that's a reasonable viewpoint. It's not necessarily one to subscribe to, but I think it's a very reasonable viewpoint to have. And my sort of answer to that would be, well, if you want that, you can get a nuptial agreement. So it does exist that to give you that certainty. But in the same breath, nuptial agreements aren't going to be suitable for everyone. We wouldn't suggest, I don't think, that everyone should get one. So, I mean, who are your sort of classic clients where, Lisa, you say, yeah, a nuptial agreement is really going to work for you? What's the situations that lead you to think this is going to be a good thing that will fit with your relationship?
Tends to be older parties. So, that may well have built up significant business assets, capital assets, income, etc., pre-marriage. Also, clients that have children from previous relationships or marriages that they want to protect assets for by way of potentially future inheritances, etc. I think prenuptial and postnuptial agreements are certainly more common in second and third marriages, in my experience, than with first marriages. And also where there's significant family wealth, often they come into it. So where there's been a big inheritance, and perhaps that's going to be used to purchase the family home, or there is a family, as I said, a family business or something along those lines that other family members wish to protect. Those are probably my top 3 situations where a prenup or postnup is really something that should be strongly considered.
Yeah, I think that's right. I think you're looking at significant assets and imbalance in those assets. The family wealth point, definitely the second marriage point or subsequent marriage point. I mean, I don't think it's... So myself and my wife got married and we were 30-ish, and we've been together for quite a long time, and we didn't really have anything. We were just very, very normal. We don't think we owned a property at the time. There would be absolutely no point in us getting a prenup because we didn't have anything. Everything had been generated. What we did have was generated between us. So, if you're in that sort of position, it's probably not worth it because you're sort of starting from a clean sheet anyway. So there's no advantage. What you need to look at is, do you have something that if you were to separate, you would feel that it's unfair that you would have to give up a share of that? That's kind of the question. And the sort of pre-built, pre-acquired assets, inherited assets, whether they're already inherited or stuff that you anticipate inheriting in the future, and you want to carve those out as being separate property, that's really key. And the leaving stuff for kids is a real powerful motivating factor. And that's when you get a situation often where actually similar assets, you've got similar assets, you've both got a property, both the husband and wife to be have got a property, but they want to make sure that, once bitten, twice shy. If they get divorced, they've both been divorced before, they stay with their children. So I think that's the sort of the most common ones. I think what for me is most challenging about prenups is there's a lot of crystal ball gazing, isn't there? It's you're presented with a situation of here's what we've got, and then maybe we should just do a little peek behind the curtain for people in kind of assessing, okay, well, I've got this and my spouse to be's got this. What do we get if we divorce when? How do you go through that process, Lisa?
So usually they come with a preconceived idea as to what they think would be fair for the prenup. And I suppose for simplicity's sake, it will often be that the party has more assets is saying, I want to ring fence all of these assets and make sure that the other party cannot make any claim to them. And, using the old crystal ball, we can kind of look 3, 5, 10 years down the line and consider that, if the parties were going through divorce proceedings in these circumstances, the court is very, very unlikely to allow one party to walk away with all of the assets. And the reason for that being that it doesn't meet needs. And so I suppose it's then having the conversations to say, actually, to give this prenuptial agreement the most chance of being upheld by a court, we need to make sure that it at the minimum is meeting needs. So perhaps we need to be giving something, so even a housing fund, or what's the income going to be if the relationship broke down. And those are really difficult questions because we don't know if the relationship is going to break down, when, or what the assets will be at that time. If the marriage breaks down after a year, then okay, that's slightly easier to predict. But if we're talking 15, 20 years down the line, a whole host of things could have changed in that time frame. So it is about having conversations with clients about making sure that we're sort of considering the prenuptial agreement against the backdrop of the sort of statutory criteria within divorce proceedings, to make sure we tick as many of those boxes as possible. But as you say, we can limit it. So rather than it kind of just being to meet needs generally, we can limit those needs much more. So we could set out, for example, in the prenup that we think it would be perfectly acceptable, both parties think it would be perfectly acceptable for the other party to have a 2-bedroom flat in a certain area or something along those lines. So you can really limit the claims in that respect. But it is really, really difficult because we don't know. And I suppose that's why we have reviews built into these agreements, and they're really important. And sometimes I know parties, they want the certainty. We spoke about, having a degree of certainty is an advantage of pre and postnuptial agreements. But the difficulty is when they start adding in reviews, they worry that that takes away from all of that, whereas actually it provides it with much more strength. The agreement has far more strength if, when there is a child born, or if one party were to lose their employment, or if the assets were to change significantly, you relook at that agreement and you record that you've done that. It gives that agreement far more strength than if that's not done and the circumstances have just changed, and then you end up in divorce proceedings where a judge turns around and says, well, I can see what you meant at the time, but that's not going to wash now. I'm not sure if I answered your question there. Or
No, I think that's clear, but it does illustrate that there's a problem in that.
Yeah.
In the crystal ball gazing thing, I use that phrase because it's a phrase that family lawyers use quite a lot when we're dealing with clients who are getting divorced and say, well, if I give this up, then in a few years' time, then I'm not going to have this or I'm not going to have that. And then we say, well, the court isn't going to crystal ball gaze. It's going to address things as they are now. And then we do prenups and all we do is crystal ball gaze. And they're slightly counterintuitive. I think what you said about setting a sort of housing need, because most agreements, unless there's oodles and noodles sloshing about, most prenups, postnups are going to focus on providing a housing need, maybe a pension, maybe income if there's a spousal maintenance claim. That's the main thing. Generally, it's limited. Housing needs is the most common thing. So saying a 2-bedroom flat, a 4-bedroom detached house, whatever, is one way of going. I had that conversation with the client on Friday. And kind of weighed up the pros and cons of doing that. That's a bit more flexible, but you lose a bit more certainty, but you're pegging housing needs for definite, as against lump sums, which may or may not be right because it depends on what the housing market decides. And his preference, and he's going to go away and speak to his wife to be about it, they talked about lump sums, but in that case, we're doing stepped lump sums. So after 0 to 3 years, it's X, 3 to 6 years, it's Y, so on, so on. And then you can have those. There's one that I've emailed the solicitor on the other side about this morning. We're trying to get one boxed off at the moment that is, as it happens, well within the 28 days, but with no issue on the timing because of various factors. And that's for a reasonable amount of money. That's it's sort of in the millions. But we're finalising that, and I've gone back and said the lump sums are fine over these periods of time, but we need to increase it by inflation because a lump sum of £1 million in 5 years isn't going to be worth £1 million, for example. So that's just a couple of little examples, and it doesn't have to be millions of pounds. My other one I was talking about was a lump sum that's going to be like 50 grand in 3 years. So there's different levels. This perception of it being for celebs, and a lot of celebs do have them because a lot of celebs have got assets. That's the way it works. But they are increasingly commonly for the man and woman on the street. So I think, but it is really hard to say with great deal of certainty what the provision should be. So that's where you bring in the insurance policy analogy, and that's where the case law kind of says, well, look, even if your prenup's not quite right because it's been a bit stingy, it's not met needs, it's still going to reduce overall claims, and that's the benefit to the wealthier party. Obviously, the less wealthy party is going to be advantaged by not having one.
Yeah. And I think both parties need to go into these. You don't sign one of these agreements. It's all well and good us saying they're not 100% legally binding, but still, you don't sign one of these agreements unless you're absolutely prepared to be held to it. And I don't think the celebrity, we see the celebrity prenups in the divorce in the press quite a lot, don't we? I mean, I heard about Beyonce's was in. Can't remember what I was watching, but it was mentioned again the other day that she would get X amount. I think it was $1 million or something per child that she gives birth to. I don't think those necessarily help us because people hear that and they think, oh, well, yeah, prenups absolutely don't apply to me because, I don't have that sort of money to be considering that or paying out X amount of money if there's an affair or whatever it might be. And I think it is just about saying to people that, no, these are for everybody. And it's just about, finding that protection for yourself and having those conversations with your fiance or husband and wife, and setting the expectations.
Yeah, completely. And a lot of it, just to touch on there, we're not hugely talked about, is the sort of the family wealth point. Quite often they can be driven by mum and dad, and they have gifted or will gift money or an interest in a trust or shares in a family company to their son or daughter. And understandably, if they don't want after a divorce, especially if there's a family company involved, which they have, blood, sweat, and tears in over the years, is to then see that form part of the claim. So, they might say, well, we're going to gift you these, but there has to be a prenup or a postnup. Again, really not great conversations to be having with your in-laws. You can do them really well, and I've known people do them really well. I've also heard them go not so well, and there is a danger that someone goes, well, the wedding's off. That can happen, sadly. But I think that sometimes that can be the lead on it, and it'd be a sensible way to kind of protect those kind of inherited assets, or farming cases where farms have been passed down from generations to generations. So quite sort of like normal people. You don't have to be Beyonce, although I'm sure we all wish we were.
Oh, absolutely.
So on from the very serious point of this is maybe equally serious in its own way. So petnups, which are a bit of a media staple and kind of not a joke, that would be unfair, but a bit kind of seem a bit frivolous having the petnups. But I'm a recent dog owner. I have a puppy at the minute. I know you're a pet owner, Lisa.
Mm-hmm.
Pets are hugely important to people, aren't they?
Yeah. And I think we see it with divorce proceedings. I mean, people can argue over their pets just as much as they can argue over their children, and would often give up far more of the assets to keep the dog.
I give up far more of my children to keep the dog. Priorities.
The dog's coming with me, definitely.
Yeah. Fur baby over human baby.
And we do see a lot of it I see a lot of it within divorce. And I guess the problem is, and what's awful about it in some respects, is that whilst these are well-loved family members to us, the court treats them as chattels. So they're classed the same as a table or chair within divorce proceedings. So there's no kind of you can't make a contact application for the dog or an application to specifically decide, who the dog's going to live with. And, these all have to be made within other applications. And it's costly, because if you've agreed everything else and the only thing you can't agree on is who's going to look after the dog, you're going to be racking up a lot of legal fees on that point, which could have been avoided. And I suppose that's where this idea of a petnup comes into place. And again, it's just about having that open communication and setting expectations right at the beginning as to who will get the dog if the relationship breaks down.
So, I mean, someone enters into a petnup and they do it and they get it properly written down and things. I mean, is that binding?
Well, no, it's going to be the same as a prenup or a postnup. So it's not binding on a court within divorce proceedings, but I think it would be heavily persuasive on a judge in divorce proceedings.
I think a judge would be more likely to stick with that if it was properly executed as a deed. I can't say I've ever had one in proceedings, but I think a judge, because as you say, it's chattel, it's it's a thing, it's a sofa. The judge will say, well, you've entered into agreement and that's how we're going to deal with it. The court doesn't have, as opposed to a prenup and a postnup, where the court's got to step back and say, well, is this fair? I mean, the court isn't interested in fairness when it comes to a cat or a dog, so I think it probably would be. I'm sure at some point there will be a test case, whether it's a case law on whether a petnup is binding. I'm yet to see it. Have you ever done one?
I haven't done one. I've had lots of cases that have involved dogs in particular during divorce proceedings, where it has been a really sort of messy and difficult and emotional point within the proceedings. I know, didn't we have an email come around last week or the week before about an arbitration over a dog?
Yeah. So again, peek behind the curtain on the Stowe or Fiona's email. This was a, has anyone had an arbitration about a pet? And so someone will have done, and people will do it. I have a client at the moment who looks like he will go to a final hearing to decide largely what happens with the dog. And it'll be very, very expensive, but it's that important to these parties that they want to go and do it. And, give my advice about what a judge is likely to do and say about that. But, they are really important. They're kind of slightly written off as these frivolous things. And I'm probably guilty in falling into that myself. But a lot of people, the pets are their children effectively. So, I don't know if we'll ever get to a stage where pets are treated more like children in the law. I'm not sure we will. But in terms of, I guess, the future of the law, and more applicable to nuptial agreements and petnups, I mean, what's your view, Lisa, on whether they should be binding? Because there is a bill currently in the House of Lords, as I understand it. I think sponsored by Baroness Shackleton and Baroness Deach, about making prenups binding, provided that certain formalities have been complied with. And the government has, again, we're recording this in October 2023. The government has indicated an intention to review the Matrimonial Causes Act. And one of the things that will be closely looked at as part of that review, I'm sure, is whether to put prenups and postnups on a statutory footing to make them more binding. I mean, what's your thoughts on that?
I mean, I think if we were going to make them binding, we would have to ensure that there was a lot of safeguards in place, particularly for the economically weaker party. And I think that would be my only concern about it, is making sure that we're not in a situation where somebody can be forced to kind of sign up to one of these without a full knowledge of what they're doing, or without sort of full disclosure. And I know certainly at the moment, if parties don't want to go through the full disclosure process, it may be that, you know, we get them to sign a disclaimer, we give them the advice, all the rest of it, and they may choose not to do sort of full exchange of formies or whatever it is. I think there would have to be much more rigid rules on the minimum documents, etc., that needed to be provided to ensure that there wasn't any way of kind of wiggling out of that and having somebody held to something that they didn't fully understand or have a full appreciation of the assets. But that being said, I don't know if I'm going to be overly helpful here, because I kind of sit on the fence with it. Because that being said, on the other side of things, I do believe that we are now at a place where, if people have obtained advice, if they've got a full appreciation of the assets within the marriage, that they should be able to make a decision themselves together as to what would happen on their relationship breakdown, rather than that being up to a judge or lawyers through the divorce process. So I don't know. I think I very much sit on the fence, because I can see the pros and the cons for both. So it's difficult. Where do you fall on it? Do you have a preference?
I think I'm probably not a million miles away from you. I think I probably lean towards putting them on the statutory footing. I think that with sufficient safeguards in place, I think that if parties have entered into an agreement with the benefit of legal advice and full disclosure, I can't really see why they shouldn't be held to that, unless the needs of minor children are met. I think if there are children, then obviously there needs to be met. But I think if someone's going to sign up to a prenup, they need to expect that they're going to be held to it. And if that means that they don't come out of it with very much at the end, well, it was, you know, is there an element of personal responsibility on them to have not entered into it? And if it comes down to it, and what people will say to that is, well, you know, maybe that means that the marriage doesn't go ahead. And maybe that's something that will happen, the consequences of that. My slight concern is, does that push more people into only cohabiting? And obviously cohabiting's on the rise, and we have done a previous podcast where we've disagreed about what should be done and whether cohabitees should be given additional rights. So, you know, in me saying that people should be held to prenups a bit more readily, and they generally are, I slightly struggle when, I think the cases that I struggle with are where you see them reported and a party signed a prenup that would have given them several £1 million, and then that several £1 million is not enough to meet their needs, and they're after several more £1 million. And you kind of think, well, it probably is enough to meet your needs. Not the level that you might like them, but it probably is, really. So why did you sign up to it? And that feels a bit, I kind of feel that people should be held to their bargain. You know, they've commercially agreed something with the benefit of reasonable lawyers, then there comes an element of personal responsibility. But I do have that nagging thought as, well, does it just mean that people are less likely to get married if someone says, I'm not signing that prenup? They say, well, we don't get married, which forces people into an even worse position. So I think the two things are really kind of tied up. And and the more I talk about it, the more I think that actually you probably can't have one without having the other. And I would, obviously, as we talked about before, lean on the side of enhancing cohabitee rights a little bit, which would provide a bit of protection for those people who then feel that the prenup isn't fair for them. So that's our views on whether nuptial agreement should be made binding. But I think both us and Crumble here, and Duke with you, Lisa, are probably definitely of the view that petnups should 100% be binding. Isn't that right?
What do you think? So that's it for this episode of Stowe Talks. Thanks for listening. If you would like more information on our podcast, head over to stowtalks.co.uk, and please rate, like, share and review this podcast where you can.